Hi everyone, today we're going to talk about IP and privacy in this new world of AI where everyone is building and things are happening so fast and the law and regulation doesn't always follow up and catch up with this speed. So I'm here with Anuja. She is a lawyer in privacy and IP here in Silicon Valley, and we will just have a conversation about like a few things, how the startup are facing and using data and facing this regulation and preventing for the next step of the regulation when the law catch up and be ready for that. So yes, thank you so much for being here. It's a pleasure. And please introduce yourself so everyone knows who you are, a little bit of your background and what you do.
Of course. Firstly, thank you, Federico, for having me. I'm excited for this conversation. I'm Anuja Shah. I'm a privacy and IP attorney based out of the Bay Area. And I work very closely with early stage startups on things like privacy compliance, IP strategy, and commercial contracts. So think about things like trademarks, copyrights, the GDPR, the EU AI Act, basically all the unglamorous legal infrastructures that founders don't really want to think about until there's some sort of problem. On the personal side, being an IP and privacy attorney, I am very curious and very interested in technology per se. So, as I'm sure you've heard living in the Bay Area, I've been vibe coding quite a lot these days. And basically, it's just from like a legal perspective, it's just to sort of understand, the technical architecture that goes behind every single product.
Yeah.
And honestly, living in SF, that's not very hard to do, right? You go to a coffee shop and you'll hear people talk about AI agents, agentic AIs, MCPs. These are the conversations that you hear every single day living in San Francisco. And it's just that kind of city, and I honestly love it. So I think at the end of the day, my job is to make sure that founders are, building great products, sure, but at the same time, they're building products that are legally and commercially compliant.
Yeah, I love the introduction. That was spot on. Thank you. And actually, you mentioned something that I wanted to talk about, which is like when is the time for a founder to like start thinking about law? Because, you come up with an idea and you start building it and you spend hours building it. And the law aspect is always in the back of the mind. When is the time for them to talk to you?
Correct. That's a great question. And of course, because I work primarily with startups, this is something that we have to deal with every single day. So one of the things that I see that, a lot of startups are sort of hesitant when they have to think about legal compliance, it's mainly for two reasons. One, of course, the money that's involved in getting legal compliance in. And second, it's just not their priority. And to be honest, I completely understand, right? Like these are founders and they have other things. They're, shipping their products. They're in the middle of fundraising. They're trying to find their customers. So legal compliance is boring. Come on, let's agree to that, right? So I get that. But at the same time, what I'm seeing in my practice is, a lot of these founders who don't look at legal compliance at the very beginning, they get into a lot of trouble at a later stage. And in that situation, they end up paying a lot more than what they could have if they had just been legally compliant from the very beginning. So for example, now think there's a startup. They've been building for say 18 months or 24 months. And now they finally hit Series A, right?
Yeah.
This is when the VC diligence team comes in. And at this point, the diligence team asks all the tough questions.
Yeah.
Who owns the IP? Was there an IP assignment by the engineers? Does the company own it? Does the co-founder who probably left, 6 months ago, do they still own it? Things like, was your trademark registered, or are you just finding out that someone else owns that mark? Or does your privacy policy clearly tell your customers what you're doing with their personal data? These are questions that the diligence team always asks you, and these are very pertinent for a deal to go through. And honestly, these are every single one of these questions should be something that you have a clear picture about on day one. Right? These are pretty important questions. So having a clear founder agreement in place, having an IP assignment agreement in place, making sure your trademark is available and registered, making sure you have a very transparent privacy policy telling your customers what you're doing with their data. And honestly, if this is not in place, what I see is founders paying lawyers thousands of dollars to sort of reverse engineer all of this mess. Sometimes it is fixable, but sometimes it's not. And when it's not, we do see in practice a lot of deals slowing down, or worst case, falling through because of some compliance gap, or, startups having to completely rebrand in the middle of like a raising a round, or, startups having to pay a customer because they misused or mishandled their personal data. So, of course, in the beginning, on the first day, I get it. It is like you will have to spend thousands of dollars to, have the compliance strategy in place. But at a later stage, if you're not compliant, you may have to probably spend 10 times of that. And that's if you're lucky.
Yeah.
So I do think the best time is on day one, simultaneously get in your legal team, speak to your lawyers, and start the process at least.
Yeah. In the money aspect, the fact that a lot of startups don't really have money when the time is right for like checking the and talking to a lawyer, they don't have enough money. Like here in this Silicon Valley economy, it might be a little bit different than outside of here.
Correct.
But as you mentioned, like there are a lot of companies that like works for share and supports you in that way. So having or not having money should be your stopping reason.
Exactly. So it may be, you may think about it in a very small view if you're thinking that you're spending money on legal compliance, because sure, today it'll cost you something. Like you said, there are multiple options, there are safes, there are equity exchanges, there are different things that you can do instead of upfront money if you don't have that yet. But if you just wait on it, sit on it, and think that it's not a priority, then tomorrow you'll end up spending a lot more.
Yeah.
So it's always better to do it in the very beginning.
And during this answer, you also mentioned like the data aspect. You mentioned data, and a lot of like new companies are not only new companies, but that's something that we see here in the trends. The data is the real value of their product.
Absolutely.
And how their product is tailored to the customer is the real value. And so in order to get there, there is some data use before. And so that could be the competitive advantage of the company, but it can be also the liability, because problem can happen, in particular on the legal aspect. And you are also an expert of that. Can you tell me like, what should I do, how to do it, and what you think about this situation? Advantage, liability of the data management.
Sure, and this is something I work very closely with startups with, right? As a privacy attorney, I have to be very direct. Data is a very valuable asset, especially in today's day and age of AI. It is something, the kind of proprietary data you have will help build your model and make it better than a competitor's model, for example. It is something that VCs look at when they value an AI company. So definitely it is something that's very important, but also this very same data set can get you into regulatory or sort of litigation troubles if it's not cleanly processed or cleanly collected. So what I mean, now let's talk about it from a privacy lens, right? Because I'm a privacy attorney. So what I'm seeing these days, so in terms of privacy, whenever you're collecting personal information or personal data from your customer, the law says that it is mandatory to be very transparent about how you're collecting this information, how you're storing it, what are the rights that these customers have in relation to their personal data. And all of this can be documented in a simple privacy policy that must be there on your product or on your website, right? Now, what I'm seeing, because today AI is developing so quickly, technology is developing so quickly, there are some sort of compliance gaps. So let me give you an example. Everyone's heard about training data, model training, right? So now today, a lot of companies, they collect your data, my data. Whenever we use these products, they're collecting our personal data, and it's probably mentioned in their privacy policy. But what they are doing is they're actually using this to train their own models. Now, I've seen this in my own practice. A lot of startups, they're just like copy pasting generic privacy policies of websites or asking Gemini or Claude to build this for them, and they're pasting it. Now, what this privacy policy says is that we're collecting your personal information or your customer data, and we're using it to improve services. Now, improve services does not mean training your model. So there could be a sort of compliance gap here, because a lot of privacy laws, whether it's the GDPR or California's Privacy Right Acts, it requires like a purpose limitation. So what this basically means is whatever is the purpose you're collecting the data from, your use of that personal data should be restricted to that.
Okay.
So in this scenario, for example, if you're telling your customers that you're using it to improve services, you should just be using it to improve services. But now if you're actually using it to train your AI model, it is not covered under this particular purpose. So in this situation, you may have to do, it may require you to take fresh consent from your customer. Or you may have to do an analysis of legal basis of whether you have actual legal basis to use this for data training, for model training. So these are things you have to look into and you have to be very careful for. This is basically any sort of information you're collecting, why you're collecting the data, what you're using the data for, what you're actually telling your users, what your downstream contract says you're doing with this data. All of this has to be aligned and in sync. But often we're seeing that that's not happening, and that's where the liability gap comes in.
I have a surprise question. She doesn't know about this.
Oh, no.
No, like we mentioned that there are a lot of gray areas, and the regulation are a little bit behind compared to like what's actually happening and the speed of what's happening.
Correct.
What do you think is gonna happen? And we can cut this part if you don't like the answer. in a few years, because like there is a gray area. People are trying to figure out what's the best way to manage or to act in certain situation. At some point, these a gray area will be regulated.
Correct.
And that some things that have been done today in the gray area will not be possible in a few years. Like, how would you suggest to manage that situation right now for founders?
So honestly, that's a great question. And again, it depends.
Yeah, of course.
I see myself, saying it depends very often these days. But it does depend, right? The technology is moving at such a great speed that the law is just not ever going to catch up to that. Even many years from now, like, a few years ago, there was the dot-com boom where people had no idea what that was. Then, of course, right now we're living in this AI boom or AI bubble, as some people would like to call it. Tomorrow, there's going to be some other sort of technology that, we have no idea what that's going to be. So there's never going to be, and this is my opinion, but I don't think there's ever going to be a situation where the law will be in par with how fast the technology is developing, especially in the Bay Area, right? This is literally the home of development. So
and it might get even worse because these technology is just speeding up so much.
It is speeding
that, like,
up.
in 3 years, the speed that we will develop things is completely different than what we are doing now. And right now, it already seems crazy.
Exactly, it seems so crazy. And if you look at privacy laws or technology laws or AI laws, every single day there is some new law coming out. There's like a chatbot law coming out. There's the EU AI Act, which of course I'm sure you're aware of. There's just so many different laws. And in the US, it's even more, crazy because there are so many states. Every state is coming up with its own AI laws. They're trying to regulate laws. In the EU, of course, it's called the Brussels effect because everything started from the EU, whether it's the GDPR or the EU AI Act. So that's where all of it starts. And now there are conversations about sort of deregulating it because it was so compliance heavy that it was kind of slowing down innovation. Whereas I think in the US is more innovation friendly. They want to support innovation, which kind of means that compliance will take a little bit of a backseat. I don't know, as consumers like you and me, how good that is for us because companies are making millions and billions of dollars on our data at this point. Right? So coming back to your question, I don't think the law will ever catch up to how fast technology is moving. But the good news is people are working towards it. There is so much litigation going on currently on all of these gray area topics. We don't have answers to a lot of things yet, but at least it's a conversation starter. And in my own practice, I do see, a few years ago, like founders didn't care about any of this, but now because there's so much conversation around it, we're seeing big companies being sued for millions and billions of dollars for misuse of data, for example, or like IP infringement, that founders are taking this a lot more seriously. So they are asking questions, they're asking very important questions, and I think that's the only thing we can do is keep having this conversation and just hope at some point, at least the law is not far behind from the technology. So that's probably it.
That's nice. And in your answer, you mentioned the IP, and that's another part of your expertise, and that's another part of the topic that I would like to talk about. So as we mentioned, right now, everyone is building things. I'm building things. You're building things. Everyone is building. And IP, in my head, in this world of software built by a machine, is a concept that is getting very malleable, it's changing, it's switching. So how do you see that? What does that mean for a founder? And what is really IP anymore?
Correct. And that's a super interesting question in today's day and age, especially technology. Again, like I was mentioning earlier, technology is moving at ridiculous speeds these days. Something that was true a few years ago is completely changing now, right? When we talk about software particularly, a few years ago, traditionally, when you talk about IP protection in software, and I think we were having this conversation earlier today. When we talk about software, IP protection means protection of your source code. It could mean, trade secrets in maybe your data sets, or it could even potentially mean patent if you have something novel to sort of register. But now with all this new technology, for example, LLM specifically, right? There's so much that's changing that this line is blurred. It's, again, like I've said so many times already, again, it's a very gray area, right? So think about it, like a lot of startups today, and since I'm building, we all know that any sort of products that are being built today is built on top of something. So this raises a lot of questions. So number one that I think is a very important question to discuss is authorship. Now, startups are building on top of frontier models or on top of foundation models like your OpenAI or Claude, Anthropic's Claude, right? Now, what happens in this case? Foundation models like these are being used to even write code today. They're used to structure a design. They're used to write content. In this case, who really owns IP? Who really owns copyright? So from a copyright perspective, copyright exists in original work, which is with some sort of human involvement.
Sorry, problem with the lights.
Blooper two.
Exactly. We can keep going. Yeah. Sorry for.
Yeah, of course. So copyright really exists in original works of art, artistic, literary sort of work, and it exists when there is some sort of human involvement, right? Now, in this day and age of LLMs and AI, when your product is built on top of an LLM, the AI that is generated, the AI output as we call it, who really owns that? Now, the US Copyright Office has had some discussions on this, and they have clearly indicated that something that is completely generated by AI, that is not copyrightable.
Okay.
Why? Because there's no human author behind it, which is the very basis of copyright protection, right? So that is one point. But now, and this is the interesting part, what happens if it's an AI, a human-assisted program, right? Like, for example, like you put in a prompt. When you're asking Claude Code, for example, to build something. The prompt is your creative element, right? It's something that you thought about.
That's following a certain path and certain things.
In a certain way, it's something that you've created in your brain, right? It is your artistic or your literary output.
The AI is just doing it.
The AI is just doing it. But at the end of the day, that's the blurry line, right? What happens in that case? It's still, AI is still building the output, but you're the one putting in the creative element. So it's human assisted. It's not completely AI generated. What will happen in that case? Do you think you own the IP? Do you think the company like an Anthropic or the OpenAI who's built the model, they own the IP? Or who owns the IP? Or is it the people whose data was used to train these models? Do they own the IP? No one knows, to be honest. But the good news is there is a lot of litigation going on. There are questions being asked in courts. We don't have an answer yet. But practically what startups need to keep in mind is they should stop presuming that all the output that the AI product is producing, they have copyright over. That is just not the case in today's day and age. So that is question one. Then the other interesting part, which is the second point that I'd like to discuss, is your training data itself. Right? Now, today, all these companies are using data, the scraping data from publicly available information, right? Or licensed data, or user-generated data. In this case, is the training data itself considered as copyright infringement? Do they need permission? What is the case? Again, no clear answer. But again, good news. There is litigation going on. And I'm sure you've read about ongoing litigation with Midjourney or OpenAI. It's still in the courts. But the good news is we still don't, I don't know if that's good news, but we don't have an answer as yet. But at least the conversation has been starting.
It's happening.
Exactly, it's happening. So it's, in this case, the risk is real. And I think what startups need to do is they should document all their data sourcing. So something like this comes up, they at least know where the data has come from, where was it sourced from. So that's important to remember. And then the third thing, which I think is not spoken about enough, is trade secrets. While your AI output, you probably cannot have a clear copyright protection over it, there are some things that can be protected under trade secrets. Whether that's your data sets, whether that's your fine-tuning methodology, these are things that can be protected as a trade secret, provided that you treat it as one. What does that mean? So if you want something to be a trade secret, you should make sure there is access controls in place. Your employees sign NDAs. You do not open source things that you want to keep as a trade secret. So these are some important points that startups should think about when they're building products as well. So coming back to it, we're living in a crazy world right now, living in the Bay Area. It's always interesting to see all these new technologies come up. And as a lawyer, it is interesting to see how far behind we are when it comes to technology. But at least, like I said, the conversation is starting, and there are certain things we can, guide startups to think about right now. So at least they can be compliant in the future.
And in this answer, I feel like you mentioned some call to action for startups of what they should do. And this is also the reason why you, as a founder, you would like to, and you should, talk to a lawyer right away.
Absolutely.
Because a lot of the things that you mentioned are like really, really hard to do when the product is completed and is already out there.
Exactly.
Like it's easier to do it in advance and be ready for like when the regulation will come, or even like just to track, etc., to patent things right now. Is there a difference between like what a small founder early stage should do compared to like someone that is planning to like build a multi-million-dollar company?
So I think we're in the Bay Area. Every founder thinks they're building a multi-million-dollar company.
You're right. Million is not enough here.
It's not enough. We're in the Bay Area.
Sorry.
$1 billion is when the question comes up. Exactly. But I think I would say the same thing. I think from the very beginning is when you should make sure you're legally compliant. Yes, there are some things, because I work with startups so closely, there are some things that need to be done immediately, and there are some things that can be spread over the next few months or years potentially. But it's still the best time to go to a lawyer is in the very beginning. And of course, the good lawyers will show you what needs to be done immediately and something that can be, stretched over the next few years.
Thank you so much. This was super interesting, and I hope our watcher enjoyed it. And thank you.
Thank you so much for having me.